The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to discuss when to hire a probate attorney. We're going to talk about when it makes sense to hire a probate attorney even when an estate doesn't have to go through probate. We're going to talk about when it makes sense to hire a probate attorney if an estate is going through probate. And third, we're going to talk about who is responsible for paying probate attorney fees. So let's first talk about the difference between going through probate and not going through probate. So when someone passes away with any significant amount of assets, really, probate is a court case that is usually necessary in order to give the executor the power to claim those assets for the estate and then distribute the assets to creditors and heirs. So we've got an article and video about when probate is necessary, so we won't go into a ton of detail here. But for certain small estates, probate may not be necessary, and the estate can be distributed outside of court with something called the small estate affidavit. But for smaller estates, certain rules about how the estate is supposed to be distributed do apply. And if the executor, administrator, or trustee, whoever is administering the estate, makes a mistake with how the estate is distributed, so if they pay off creditors in the wrong order, or if any of the beneficiaries get less than they're supposed to because the estate wasn't handled properly, either assets were missed or the assets were distributed incorrectly, then the person who distributed those assets it becomes personally liable and can be sued for damages for any difference in the distribution from what should have happened. So the main reason to hire an attorney when you're distributing assets outside of probate is because it can prevent you from incurring liability as the administrator of the estate. You're still on, even if it's outside of probate, you're still on the hook for doing things wrong. Now, if it's someone who passed away with a surviving spouse and it's pretty clear that the surviving spouse is getting everything, or if it's going in equal shares to surviving children and that's clear and there's not a lot of debt, then you can potentially get away without hiring an attorney. A lot of times people will call us in those situations and we will help them prepare the small estate affidavit, that is the instrument that allows them to distribute the estate, and give them some minimal guidance, but not really have to spend a lot of time working with them on the estate. It's really up to you on how involved you want the attorney to be to save you the headache of dealing with the estate. But certainly in anything that's even a little bit complex, even outside of probate, you're going to want an attorney to protect yourself as the administrator from personal liability for doing things wrong. Not to mention the fact that it'll save you a ton of time because there's still a lot of steps you have to go through in order to legally do things properly. So now let's talk about probate cases. If the estate does have to go through probate, this is a year-long court case in which proper notice has to be given to known and unknown creditors and to heirs and beneficiaries. Inventories and reports have to be presented to all interested parties and filed with the court. So while it's possible, it's not legally required that you have an attorney. When probate is required, it's basically a terrible idea to do it without getting an attorney involved, at least on a consulting basis. The reasons for this, there's many reasons, similar to when probate isn't involved. First, when probate is involved, it's a lot easier to make a mistake in the way the estate is handled. And again, if you don't have an attorney, this is much, much, much more likely, and you are going to be personally liable for any mistakes that you make. An attorney will help make sure that the estate gets closed as quickly and efficiently as possible, so the estate won't drag out for multiple years and everyone will get paid out. All the beneficiaries will get their share in a timely manner, as opposed to if you start making mistakes in the formalities of what is required to be filed, it can extend the duration of the estate significantly. It also saves the executor the headache of trying to figure out the whole probate process all by themselves. Finally, a surety bond is required for most probate estates. This is basically insurance that you buy as the executor in case you do make a mistake, and if you make a mistake, the insurance will cover any mistakes you make. There is a much higher premium for surety bonds when there's no attorney involved because the potential for mistakes is significantly higher. So if there's an attorney, you're going to pay less for this, basically estate insurance, than you would if you try to do it pro se or without an attorney. So finally, let's talk about who's responsible for attorney fees. This is pretty simple. The general rule is that the estate itself pays for attorney fees. A lot of times, attorneys will have the executor front the fees, and then the estate will reimburse the executor for the fees. Sometimes attorneys will take a percentage of the estate. Sometimes it's an hourly rate. The only time generally that the estate itself does not pay for the attorney fees is when the attorney is being used to defend the malfeasance of the executor. So if someone's suing the executor saying they're not doing their job right, the percentage of the attorney's time that is spent defending the executor is paid for out of the executor's own pocket. It's not paid for by the estate. So if you have any questions, please leave them in the comments section, either below the post at learn-about-law.com or below our YouTube video on our YouTube station. If you found this helpful, we'd love it if you'd subscribe to our YouTube, iTunes, and SoundCloud stations to get updates when we have new content that you might like. If you need our help, please feel free to call us for a free consultation at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law. We have offices all around Chicagoland for your convenience. Thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.